The Law Report with Karen Key.
But on the Law Report tonight, good evening to you. And as you know, once a month here on the Law Report, we run a legal clinic with attorney Nicoline Skuman-Loeb. And she's a director of Skuman Law Inc., Attorneys, Conveyancers and Notaries Public. So this evening, we'll be dealing with all those questions that don't usually fit into any of the other regular programs we do here on the Law Report. Nicoline, good evening. Welcome back on this freezing evening in Cape Town.
Thank you for having me on this freezing cold evening.
Nicoline looks like she's ready for the Arctic Circle. I'm telling you, it's absolutely ice cold. And just before we begin, there's a reminder that there's a list of available documents on the Facebook page, Law on SAFM. And in the past week, I have added quite a number of new documents to that list. So if you'd like any of those, just post a message on Facebook. But please always remember to include your email address. Or if you don't have access to Facebook, you can email me on law@safm.co.za and I can send you a copy of the list and then you can choose what you'd like to have. We have some emails to start with this evening, just 3 of them. So we'll get moving on those. The first one, it's actually a very sad story. It's from Agri, and basically the story is that there is a gaping hole that fills with water when it rains. It's left by either municipal workers or big road contractors when they mine sand, not far from a township. Now, these multiple holes, apparently in summer, it's so hot that these children jump in there and use it as a swimming pool. And unfortunately, a number of children have died. I think there's about 15 or more of them have died there in the past 7 to 10 years. And Agri wants to know, what can we do about this?
Oh, this is a very sad situation. And of course, if there's any negligence that can be proven on the side of the contractor or the municipality, there would be scope for a class action by the aggrieved parents or guardians of these children, or even the parents individually, who have lost children in these circumstances. Usually, these type of holes are supposed to be closed up properly, or warning signs affixed around it so that, similar to puddles and that sort of thing, and manholes really, one is supposed to at least warn bystanders of the potential dangers. So, on the flip side of the coin, except for the legal remedy, of course, the community can also, take some more proactive steps in order to prevent these children from actually making use of these holes, so to speak, as for recreational purposes. And similarly, if it's on privately owned land, the landowner also has a role to play. So it depends on how the relationships legally are put together from the contractor and the municipality and the landowner's perspective in order to see if they were to bring an action, who it would be against. But overall, there are multiple role players that should be taking some more proactive steps, including the community whose children is being exposed to this.
Now, I mean, he says that it's either left by municipal workers or big road contractors when they mine sand. Now, if it's a sort of a mining area, would they be expected to close those holes up every day after they've finished working there?
Yes, as far as my knowledge goes, and also the occupational health and safety provisions would also make a cause for liability between the landowner and the people working, the municipality developers, whoever the role players really are, the contractors. So in terms of the occupational health and safety, you have to take reasonable steps to make the area safe, for lack of a better phrase. But as I said, I think there's a bit of an onus on the community as well to maybe prevent their children from using this recreationally, particularly when they've seen the dangers that this holds. But it doesn't excuse the other parties from their steps that they should be taking in order to prevent this.
Right, so we have 2 more emails to get through, but if you'd like to call through in the meantime, the number is 0892 10 2010, 0892 10 2010, and you can leave your name and number with my producer and we will call you back quite shortly, in fact, because we just, as I said, just have 2 more emails to get through. The second one is from Golile. It's quite a long, involved email, and it's one of those terrible stories about bad service relating to a car. And he bought a car, a Hummer, in 2008, and bought it new, never missed any routine service for the purpose of maintaining the car. He's been using a particular motor dealers in Johannesburg since 2008 until July 2011. And then he moved to East London because he got a transfer. And Also, again, never missed the service and paid a lot of money for those. I think you do that when you have those services done at the garages. And both the garages did not give me good service, he says. In 4 ways in Johannesburg, I paid 95,000 Rand in 2011 for my engine. This was in exclusion of the monies I paid for the service, which was never less than 4,000 Rand at a time. Surprisingly, my engine got knocked in spite of servicing it regularly. As if this was not enough, I paid 43,000 Rand in the same year for changing my engine by force. I'm not quite sure what he means by that. The money was for the gearbox. This was knocked, and they told me it was because of the oil. They said it ran out of oil. How can my gearbox run out of oil when it's being serviced regularly, and why did they not pick this up? Aren't we supposed to check our own oil every time? I'm just asking when we go and fill up with petrol.
No,
or
sure.
Maybe that's just me being overly neurotic and I do it anyway.
No, I think that's just one of the reasonable steps that motor vehicle owners should also take on own accord. But if you do take your car for a service, surely the service includes checking.
Oil check, right. And then he said, brought my car in June this year, 2015, for a routine service. Now, the new garage, the one he's now using in East London, told me they are going to do a minor service. My car had nothing wrong when I brought it in for routine maintenance, but a few days after the service, my car showed signs of discomfort. I brought it back explaining the complaint. They took it to investigate the cause and came back saying it is because of my driving shaft, and they said I needed to pay 9,000 Rand. I could not because I did not have this money. I just paid them close to 2,000. I argued, then they said it's an electrical problem and I need to pay 23,000 Rand. Took my car to another service provider. They told me nothing else was wrong with my car except the plug points, which they hadn't been changed for a long time. They also pointed out my fan belt was loose and needed to be replaced, and I paid more than 4,000 Rand for this service. And he says, I need help to be compensated for the loss as a result of the poor service from the first general dealers and also from the one in Johannesburg before he left there. So and this is just like an ongoing story of not having good service from a number of different
car
dealers.
This always becomes quite complicated, particularly because I'm not too acquainted with all the mechanics of the servicing of motor vehicles and all of that. But be that as it may, in terms of reasonability of good service delivery, particularly if you're taking your vehicle to the dealer and you're not taking your vehicle to
little backyard operation.
A backyard operation, for lack of a better phrase, then you should expect a certain level of service delivery. And you do this in order to maintain your guarantee that you get with your newly purchased vehicle. So there is a reasonable standard of service delivery that should happen. Many of these bigger dealers or often are members of a number of organizations, including the retail motor industry, or the RMI, which is a similar type of ombud structure. And similarly, the Consumer Commission should also have jurisdiction in this regard. In fact, the Consumer Protection Act has prescribed that in order for you to authorize certain repairs and works to your vehicle, you are supposed to be given a quotation before any work commences, so that these costs cannot really be pounced on you. And even though I'm not too acquainted with all the mechanics of what should be expected or what should have been done and so on, it's quite clear that costs were simply incurred, services were simply delivered without any quotations taking place, or that's what it seems like anyway from the contents of the email. So on that basis, one can definitely approach the Consumer Commission and say, you know what, they didn't follow the process, they didn't give me a reasonable notice in terms of what could be wrong and what cost implications it could have. Similarly, you could also go to the industry ombud, the RMI, if they are members of the RMI, particularly when it comes to defective parts and so on. That
the one point here, though, he does say they said that it was now, first of all, it was one thing. They said it was the drive shaft, and then he would have to pay 9,000 Rand. Then he said he couldn't do that. Then they said, oh, no, hang on, no, actually it's an electrical problem. It's now 23,000. So they didn't actually do the work. Yeah. They were just telling him. And then he took it somewhere else, and they said, no, actually it's just the plug points.
Yeah.
So I mean, obviously it's...
No, sure. That's just the final straw that broke the camel's back. But if you look at the whole story from 2008 and all the services that were the gearbox that packed up and the engine that packed up and all these things up and until the last service which you referred to, which wasn't actually conducted from what we can deduce here, but there was definitely a history of this
Poor
broke and
service.
there's a big account on its way. So, that would be the first point of call. Of course, if you start adding these amounts up, they would be quite substantial. Bearing in mind that this is quite a large dealer who would have legal representation of, I would presume, a relatively big firm of attorneys, it could become a costly exercise to immediately go to court. And therefore, I would rather recommend trying the RMI first. If, we'll need a bit more details to determine which of the structures would be most suitable. But at this stage, I can say the RMI is a possibility if they are a member of it. Or the retail motor industry, in other words, or they can also go to the Consumer Commission. And that's also an option, any consumer-related complaint. If that fails, then, of course, the only recourse that remains is actually issuing a summons. But, from what it seems, it could be quite costly, and already a lot of money has been spent. So
rather go the
rather
Ombud or
try and go the
Consumer
Ombud
Commission
route first, yes. I would recommend.
One more email left, so if you'd like to call in now and leave your name and number, 0892 10 2010, 0892 10 2010. Right, the next email is from Aubrey. It says, can you please assist? I was garnished on the 24th of May 2012 to pay the amount of 7,766 Rand and 36 cents. I paid it with installments, and it gives us a breakdown. After finishing paying the last installment on the 15th of June this year, I emailed them and I was told I still owe them 917 Rand and 68 cents. And then he says, please see the attached statement, which he sent through, and it is pages and pages, and quite frankly, it's very confusing what they've sent through. What should Aubrey do about this?
Well, firstly, it's a firm of attorney, so if it's which just from a comment perspective is at least a better position than to be dealing with a debt collector. A debt collector, although some of them are regulated and they should be duly registered with the council, are not always. So some of these guys ask charge tariffs that they're not supposed to charge, and the fight in order to get that rectified is sometimes quite an uphill battle. At least you're dealing with an attorney here. They are governed by the Law Society. They're governed by certain tariffs. We don't have a copy of the court order, so we don't know how the judgment was taken. In other words, what was the judgment amount, what was the interest amount, and what was the scale of costs awarded.
Well, they've got it on this email here. The amount outstanding was 2,998. This is the final account.
Yes.
And then he's given us the interest, so the costs, and the collection.
But it doesn't say
the
on
original.
what scale the costs have been
It says
awarded.
15.5% per annum.
Yes. From
That's the
2012
interest,
to date. So
yeah.
that has been, but I always prefer, before giving an opinion on matters like this, to actually see the court order, because that can, sometimes you see these guys including all sorts of other costs within the amount outstanding under that heading, or the opening balance. Then it actually includes a judgment amount and admin fees and all sorts of hidden costs. So I prefer seeing the court order so we can see what the court has actually awarded these guys. And then, of course, what scale of legal costs. Now, scale of legal costs becomes particularly important when you look at the actual itemized cost for certain things. So
because this has been itemized up the wazoo here. I mean, there are just pages of this.
Quite frankly, some of these charges have zeros next to them. The only thing that is properly described actually is the interest, and then obviously a collection fee that the attorney is
and the
allowed to
installments
take,
are on there, and
the payments that are received.
Why would they have so many things with zeros on them? Because I was fascinated by that.
No, this is quite, with all due respect to these attorneys, this is not only a confusing statement of account, but poorly set out.
Yeah,
quite frankly. So my recommendation to this listener would be to have this bill of costs. In other words, all these legal costs, 43 Rand, 4 Rand, all these things that actually do have amounts next to them, for them to actually go to court and have the costs taxed. And that actually means that they'll go through the costs, make sure they're reasonable at the right rate in accordance with the court order. Or if the listener doesn't want to go through all that effort,
how much is that going to cost to do that?
You'll have to get yourself an attorney.
Oh, and he's outstanding 900 and something Rand. Is it going to be worth it, though?
So, in my humble opinion, I would rather advise the listener to pay this last installment up. And
well, could he not go to them and say, look, could you just do this in plain English? Because this is it's seriously a confusing
statement. You could, if
statement.
they're going to do it, it's a different story. But you can always ask.
Because that's very
confusing. Or get your employer to contact these guys. Because, it is a garnish that the employer that the employer is enforcing. So maybe it would get more, in my experience, if a bill of costs, an account from an attorney looks like this one, if you make a friendly phone call and ask for an updated statement or checking or something, you won't get any reaction.
He also says that he does subscribe to one of those, where you often see the adverts on television. You can actually join and have one of those legal sort of contract things where this company will help you out. You buy in a monthly insurance kind of thing. He does have one of those things, apparently. One of those.
Then phone them and ask them to have
a look at that, just to
taxation.
It.
Yes,
tax it. Okay.
So what they'll probably have to do is to get a copy of the court order to see at what rate, what scale the legal costs have been awarded, and then to go to court to challenge the accuracy of this account in terms of that award.
So seeing as he has that, he obviously pays a monthly premium for that.
Yes, if they're willing to do it, because remember these guys also are sometimes quite clever. If anything happened pre-membership, so let's say you got membership in 2015, this came from 2012, then they don't touch old cases. But rather make that phone call, establish whether they will assist you. If it's not going to cost you anything extra, fine. Go through those attorneys, challenge it, tax it, and do what you need to do. Otherwise, quite humbly, I would recommend it's 900 Rand. I know it's a lot of money, but it will cost you more if you have to hire an external attorney to go and take this further. So rather just go to their offices or have your employer contact them, make the final payment and put this to bed.
Right, so let's go on to the calls now. If you'd like to call in, 0892 10 20 10, and off to Cape Town first with Eric. Eric, good evening.
Good evening, ma'am.
Hello, how can we help you, Eric?
Yeah, I've actually got a problem. About after 2.5 years, I had a dispute with my ex-wife, and through the court industry, I had to leave my house, and we've got 3 children. So those children at the time were actually going to school somewhere in Green Point that I don't want to mention the name. Mm-hmm. And after that, then what happened is that, we got separated. We had to stay away from another, no phone call, nothing. But for some reason, because we had to call each other. And at one stage, we tried to sort this thing out. And then I moved back to the house. That is obviously without the quantity having been removed. And then we sort of fought again. Then I left. And then there was another, I broke the window because I needed some things. And then the house was locked and she was inside. And then after that, it went on. Then I left. So the case after that, they could not find anything against me. But now the problem that I have is that I want to have because we were married this traditional law. And now I'm having a problem. The kids, I want the kids to be here in Cape Town, to go on the same school or a better school, because I can afford that. But now the problem is that it seems to be a problem. I don't know whether she's trying to use kids on this to fight me or something like that, but I don't know. But I also would like the kids to change into my surname since they were the marriage kids. So this has been puzzling me for quite some time, and I'm seeking now a legal route. Because now recently I was in the house. There's no problem. I go to the house whenever the kids are there. And then she doesn't call police or anything. But for me, I don't understand when must I go to the house or not go to that. In fact, I'm not interested to go back to the house.
Eric,
it's just that I need to have full responsibility on the kids and get the kids to be on my surname.
Okay, Eric, let me just clear a few things. It sounds like, did she take out a restraining order on you?
No,
Yes.
protection order.
She took a protection order, so you weren't supposed to go there, but she doesn't seem to mind you going there now. And what you're basically wanting is to put your children's on your surname. But if you were married, why were they not registered under your surname in the first place when they were born?
Yeah, because at the time she hadn't changed. When we took a lot of time before we changed the surname. When all the kids were born, she hadn't changed the surname up until at this stage. So automatically, when they came out of the hospital, they were having her surname, even though the names and everything were named by me.
Yeah, because
So
I mean
yeah.
that even, I mean, I don't know if I'm wrong here, Nicolene, but even if you're not married and the father is willing to put the child on his surname, you can do that.
Yes.
It doesn't have to automatically be on the mother's surname.
No. The minute the child is born, even at the hospital, the relevant forms are completed at that point and submitted to the Department of Home Affairs. So there needs not be a marital relationship even between their biological parents.
So what does Eric do now? Because now these children have got under the mother's surname.
Well, he'll have to get himself an attorney. Firstly, I would say a number of things need to happen. Firstly, you'll need to have this protection order rescinded or cancelled, so that she can't use it against you when and if it suits her to do so. Misuse it, for lack of a better phrase. So that's the first aspect that I would deal with as soon as possible. Because you never know when there's a bit of bad blood and, she calls the police under the auspices of the protection order being enforced. So that's the first thing that I would say you need to deal with.
Do you want to say something, Eric?
Yeah, basically, that is also part of the problem that I have, because this is all to me, the mind game, because now recently, these kids were supposed, I paid for the kids, 3 of them, they are paying the full price from the Eastern Cape up here. And then I paid for the clothes, and then the school fees also. But now, she cannot allow now the kids, since I'm actually outside now of Cape Town, I'm living in the outside areas. I don't want to mention the town. But I've only seen the kids once.
Okay, so basically
she's before I could, see them.
So she's taken them to the Eastern Cape now?
They are still here, but I must still pay for them, which is not a problem. They are my kids.
Yeah.
It's not a problem to pay for them back, but the problem is when I must have the kids or when I must see the kids. But to pay, it's fine. I'm allowed to pay. That is where my problem is. I need to take step on that.
Okay, Eric. So basically, it's well done. A lot of fathers don't pay, and they're now being blacklisted, apparently. Well done on paying your maintenance. That's very good. Am I correct in thinking that you're in the Cape and your children are in the Eastern Cape? Is that right?
Yes.
Okay, and now you also wanting to sue for sole custody of those children. Is that right? You want them to live with you?
I don't. That's not what I want, ma'am. To be honest, I am actually comfortable when they are living with her there in the house. But my problem is the school, because I had a vision for my kids. Because I studied in the Eastern Cape, so I know how it's like. It's been a bit improved, but it won't be better than the Western Cape. So I would have liked them to come back to Cape Town and to change the surname and anything else that has got to do with paying anything like that. I don't have a problem. I actually want to be responsible for them.
Okay, well, let's hear what Nicolene has to say. So he not necessarily wants full custody, but he wants them to come to Cape Town, but the mother's living in the Eastern Cape, and he wants them to go to a better school here, he says, basically.
Sure. Well, firstly, as I was saying, I think you need to deal with that protection order, and adjust it, cancel it, rescind it, what needs to be done, so that it can't be used or abused as such when the whim strikes. So that's the first point I wanted to make. And even though it's got very little to do directly with your children, it's something that I would strongly recommend you attend to. Then when it comes to your kids, changing the surname, as far as I'm aware, there isn't, if you can get the mother to consent to the change of the surname, then it's a question of filling in a couple of forms with Home Affairs, and it's a fairly simple process. If she resists, she doesn't want to change the surname, then you'll have to approach court and you'll have to make application for her to be compelled to do so, if it's that important to you. So then you'll have to get yourself an attorney and they'll assist you through the process of bringing such an application. As for having the kids either more regularly or also just to put them into a better school here in the Western Cape, as you wish to do, that can also just be included in a court application to vary your maintenance order. So it will probably also then include a few additional responsibilities besides the payment that you are already making. It may increase the payment even, but if this cannot be negotiated and put to paper and made an order of court amicably between you and your ex, similarly, you'll have to approach an attorney who will be able to assist you in bringing this application.
Okay, Eric, good luck to you. Sounds like you've got quite a job ahead of you, but good luck with all of that.
Thank you very much.
Thanks for calling. Good night to you. Bye-bye. It always makes my heart very glad when I hear fathers who are paying maintenance. And a lot of them I've heard on this program say, well, I'm not getting visitations, so do I still have to pay maintenance? Yes.
No, definitely. But
and Eric's not getting to see his children as much as he'd like, but he's still paying every month, which is...
That's really great.
It's great.
And I mean, there are these new, well, not new, but more better known these days, mechanisms such as mediation, wherein you can actually sit around the table and negotiate better custody arrangements and all sorts of things, visitations. And, there are all these options. You don't necessarily just have to run to court. It's much more competitive cost-wise to go that route. But, if people are not amicable or negotiable, then you can't force them to be. Then you only have one alternative, and that's to approach court and, for it to be costly.
Costs yourself a lot of money, unfortunately.
Right.
Off to Kimberley. Lombulelo, good evening.
Hi.
Hello, how can we help
you?
you?
Show.
Thank you.
Yeah. Look, I'm about to do an early settlement of my bond with a certain bank. And I'm told that I have to pay a cancellation fee. And it's plus minus 3,000 Rand.
Mm-hmm.
Yeah, and I'm just wondering, why does it cost so much?
Yeah, these guys... we deal as conveyancers in the firm where I'm working. We deal with a lot of bond cancellations on any given day or month, and for cancelling earlier than your term, they actually make a financial loss because obviously they've budgeted for lending you money for 10 or 20 or 30 years at a particular interest rate. Because you're now cancelling earlier, they're losing some money, so they're penalising you in order to cancel earlier. So it's their way of, as we would say in law, mitigating their damages. But 3,000 Rand is relatively low.
I've been a good girl and I've never been in arrears and I've never given them any problems.
Yeah.
I was thinking they'd pat me on the back for being such a...
Unfortunately not, I'm afraid.
They unfortunately not. And 3,000 Rand I've seen in excess of 20s and 30s being levied. So thousands. So I think you've come off quite lightly.
Oh, okay.
If that gives you any consolation.
Not really, but yes. Thanks, Lombulelo. What happens when your bond is completely paid up, and then what do you just leave it at the bank, or what do you do?
No, you actually need to formally cancel it in the deeds office. Now, many people don't know this. We actually handled a transfer of a property for a client who had purchased the property in the late 70s, early 80s, and had paid the bond finished in somewhere in the 90s, and thought, okay, well, this is done and dusted now. And when we wanted to do the transfer, there were two problems. The bond was still with one of the banks that now merged to form ABSA. And some of those old bonds were distributed between the banks, not just into the new ABSA. So now, you have to go looking for a document that may be in 3 different banks. And the documents may have gotten lost, and it delays the entire process. So particularly when people sort of pay it up and then they still live there, it's a family home, it's really important. Please do pay the 2,000 or 3,000 rand to cancel your bond.
Let me just tell you what happened to us, because our bond is paid up, but it was also paid up early, but we kind of just left it there. But the term is now coming up now. So if we carried on, if we'd been paying, it would have come up and it would have been, this is the end of the payment now. But we've paid it up before. We got a call from a firm of attorneys saying your bond is up. Your term is up, and so therefore the bank wants you to cancel it now and pay us X number of thousands rands. And I thought, well, geez, thanks very much. You're not doing anything, but they will then get our title deed back. But so the banks seem to be becoming more proactive now and saying your term is up now. You have to cancel your bond. So they are doing that.
That's fantastic, because often if it is left for so many years, then the documents that the bank used to hold for security purposes actually get lost. And then it becomes a huge issue when you want to transfer the property to someone else.
Because we left ours has been paid up for a good number of years, but the term is up now.
Yeah.
So, now they've said, now you have to have it back. So they are being proactive.
It's better to pay them the couple of thousands to get it cancelled and get your title deed and put it in a safe place before it gets lost in the system.
So maybe all the banks should be becoming a bit more proactive.
Which is great, I think. Yeah, it makes our jobs easier.
Well, there you go. Right, if you have any questions, the number is 0892 10 2010. 0892 10 2010. Praveen in Durban, good evening.
Yes, hi, good evening.
Hello. How can we help you, Praveen?
Thanks for taking my call.
Pleasure.
It's with regards to a motor vehicle purchase. I'm from Durban and I've purchased a motor vehicle from a registered dealer up in Johannesburg. I took delivery of the vehicle on the 4th, Saturday the 4th, drove it down to Durban. And on Tuesday the 7th, we noticed that the vehicle was leaking oil and water. The vehicle still being under motor plan. I took it to, it's a Mercedes-Benz. So I took it to NMI in Durban. I said, it's under motor plan. Please have a look and sort the problem out. And NMI came back to me and said, listen, the radiator is damaged and the motor plan does not cover it because it's not wear and tear. It seems to be an accident of some sort, so you have to foot the bill. And the bill for that was 12,000 rand.
Sure.
And also the battery in the vehicle is a Mercedes battery. It's a Pirate battery. And I had to foot the bill for that, and that was about another 4,500 rand. Okay. As a result, the battery not being the proper battery, the gearbox wasn't functioning properly, and the stop-start functionality wasn't working on the vehicle. So I forwarded this, or the dealer forwarded the quotation to, NMI forwarded the quotation to the dealer. And the dealer's response to me was, because I did not contact them and I elected to go to NMI to get the repair work done, they only prepared to pay for half of the repair bill of the radiator being replaced. That is option A. Option B was to go to another private company to get the radiator fixed, in which case they would cover the repair bill of that, right?
In full.
So I went back to NMI today and I said, listen, why aren't you covering the damage? Show me what is wrong. And I had a look, and it's quite clear that a repair job, someone attempted to do a repair job on the radiator, and obviously it didn't work. So I don't know what my recourse is. And in finding all this out, I was told by some expert that, listen, this car seems to have been in a front-end smash, and that's why there are certain parts missing and so on and so forth. Now, what I'd like to do is go back to the dealer in Johannesburg and say, there's your car. May I have my money back, please?
But now, what happened? I mean, you mentioned that they were prepared to pay for half of the radiator. What about the battery and the gearbox and all that stuff?
Well, I didn't get to that point because Mercedes said, listen, there's also oil leaking somewhere. And they said, well, we can really test the rest of the system once the radiator is working and the car is running. So I'm at the point whereby I said, listen, I was misled because before I went up to Johannesburg, I mentioned to the guy, I said, listen, I'm flying all the way up here. Is it worth my while? Is there no major damage on the vehicle? There's no accident damage and so on. He said, well, there's no accident damage, but there's been some work done to the left passenger door. I said, was that it? He said, yeah, that's about it. You know? So I said, it's worth my trip. He said, yes, if you don't have a problem with that repair, it is definitely worth your trip. Now, one of the documents that I did sign, it was from the Motor Industry Ombudsman of South Africa. In the document, as I'm going through it, it details the mechanical, electrical, and so on. On the body, you've got client was informed that the vehicle was accident repaired. Client inspected the vehicle and is satisfied with the condition of the vehicle. Then in pen he wrote, bodywork, passenger side spray work, more client satisfied. So basically, yes, you did bring to my attention that the door was damaged, the door was repaired at some time, but not the front end smash.
See, if you've signed it, that's not a very positive.
But they didn't disclose everything.
Positive. Well, the document exists, and you'll have to disprove its authenticity and whether or not those facts had already been communicated in the detail that it alludes to have been communicated. So, these disputes with these dealers are always very problematic because you often have these checklists that they have you sign very quickly. Initial here,
they actually specifically put in there that the only damage was the passenger door. They didn't. They actually didn't. The only damage was the passenger door. There was nothing else wrong with the car, said them. But meanwhile, the car's been in a front end smash.
What concerns me is that there is references being made, unless I've misheard the reading out, that there was it was accident repaired.
Just the door, though. Just the passenger
door.
door.
Well, I'll
But
have
no
to see the
front
document,
end smash.
for attorneys, the placement of a comma or a full stop and how the sentence is constructed determines the advice.
Praveen,
So-
you and I aren't attorneys, and we're seeing this the way that we want to see it, but Nicoline's got a whole different idea here.
What is troubling always with these dealer disputes is that they either make you sign things very quickly, just initial here and here and here and here, and here's the car. And they don't always run you through everything in the detail that they should. Now, one would also assume that if you go to a large, reputable dealer, that you don't have to be as vigilant as you would have to be with some corner operation that isn't esteemed and large. So what I always advise my clients is, regardless of where you're purchasing, you need to demand certain reports from them. Firstly, a roadworthiness, if it's a second-hand vehicle, or a pre-owned, if one wants to be more politically correct, that it's certified not being that it's roadworthy, that it has a full accident report history attached to it, and last but not least, that it's not a stolen vehicle. In many instances, I've represented clients who've purchased vehicles that were not only damaged, but were actually stolen vehicles as well. And they find their way into the legitimate systems these days quite often. So I actually advise all my clients to insist on those documents so that you can see exactly what the history of your vehicle is.
Can Praveen take it back, though?
You can try and take it back. Whether they'll accept it
But
is
has he
another
got
story.
any rights to take it back?
If they don't take it back, then you'll have to approach either the Consumer Commission, and if this is an urgent matter, that is not going to give you the love that you're seeking, because there's a lot of people with a lot of consumer-related complaints around the country, and that will be a cost-effective but not speedy resolution. Your other alternative is actually to launch a formal court action against them to compel them to actually either return the vehicle or pay you for all your damages to get it to the state that is acceptable to you.
You still want it, though, Praveen?
Not really, not after
No.
finding out all of these hidden issues.
Well, that's why I was asking. I mean, I don't know whether so much I would
Now,
want
of course,
it at
there's
this
legal
point.
recourse. If there's misrepresentation, then there is no contract. If there is no contract, we need to rely on, without becoming technical, delictual remedies in law, whereby we say, there is no contract between us because there was not consensus. There wasn't consensus because you misrepresented certain facts to me. So I wouldn't have purchased this vehicle had I been told the truth in simple terms. So therefore, I would want this vehicle to be returned and my refund given. In other words, to rely on the remedy to be placed back in the position had this never occurred in the first place.
Well, that sounds like your
So-
option there, Praveen.
Yes.
You
Then with
want-
regards to the Consumer Protection Act and the whole 6-month issue, that's not applied to
You
second-hand
can,
motor
but it's more about the forum. If you go to the Consumer Commission, you are one of, I stand to be corrected, 40,000 other people
Wow.
per month nationally. I saw on the latest website statistics lodging complaints. We've helped many clients lodge complaints. Earlier this year, we haven't had a response to one. So, it's a massive national backlog. There's a lot of consumer issues on there, big ones, small ones. So the only quick recourse you'll have is actually to go through the formal court system.
Or go to the dealer and say there was no...
Yeah, but then
Contract.
they can say, oh, okay, that's great. Take us to court. We'll see you
Well,
then.
I mean, give them a try first before you go and approach an
course.
attorney.
Of course, maybe I'm pessimistic because I know how these guys operate.
Well, just say, look,
maybe
if
lucky.
if you don't do this, I will be launching a court action.
And maybe that gets them to be reasonable.
Because you can say that they sold it to you under false pretenses. I mean, you would never have bought the car if you'd known all of
Definitely
this.
not.
Yeah.
So, you want
And
to
it's
be...
also a reputable dealer from
Yeah.
what you're saying. So it's maybe you should also tell them you will, in addition to launching any court proceedings, then hello Peter.
Yes.
Okay, great.
So please let us know.
Yeah,
if
I
you
would
could
like
manage
to know how it goes along, Praveen, because you're the second question this evening about bad service and problems with car dealers. So I'd be very grateful if you would let us know what happens.
Great, I will do. Excellent.
Good
David.
luck to
Thanks,
you. Hey?
Thanks for the advice.
Okay,
Thank you.
All the
thanks.
best.
Good
Thank
night.
you.
Right.
Yes, thanks.
Bye-bye. Right, off to Bloemfontein. Tumi, good evening.
Evening, Karen.
Hello, how can we help you this evening, Tumi?
Yes, my question is, I'm staying in a complex which is not yet fully developed, so part of it is still under construction. Now, my son, who is about 8 years old, and the other friends around the complex, they went into one of the houses, got hold of the paint, and they painted about 3 houses. It was quite a small, maybe 5 liters of paint, but it was already half. Now the developer called us as parents, says we are liable for such costs because they've already repaired. The houses were almost ready for occupation and they needed to fix because assessors from the banks were coming to assess. So they already repaired and now I'm asking, as parents, are we really liable for such costs?
What costs are they telling you that you need to pay?
It's about 16,000 rand.
Sure.
Because they reckon it was an enamel paint. Then they painted on the water-based walls. They needed to clean it. It was a dark paint, so they needed like few coats of paint to get the paint inside back to its original form.
Oh, wow.
And on the quotation stated, it's like some other figures or material were questionable, like 80 liters of paint, like such things. The glasses that
Sure.
were repaired.
Well, that's probably the paint they had to use to repaint the damaged areas.
I mean, I'm not a technical person, so I think the best would be if you know someone in the construction industry that knows, maybe a quantity surveyor even. It's a good person to ask. Ask them if those quantities, those amounts of and liters of paint are reasonable for fixing the damage. If you've established that, then you've at least made sure that the amount that they're claiming from you is not exorbitant. And unfortunately, as parents, we have to stand in for the things that our children do. So there is unfortunately a link in terms of the liability. It's the same thing for employers. If your employee gets into an accident or, goes for a party and then gets behind the wheel of the company car and damages someone's property, you as the employer are similarly liable for the damages that is caused. So, under particular circumstances, but just for ease of explaining the connection. As parents, we are responsible for the actions of our minor children.
Now, you said that there was only half a tin of paint that they got hold of, but that if they'd put a little bit of that half a tin of paint on a number of different walls, all those walls would have had to be sanded down and rebase coated and repainted, and that is why they would have needed so much extra paint
Yes,
to
that's what they
rectify.
explained to me.
They would have that to me sounds reasonable.
But I'm looking at it differently. I'm saying because it's a construction site, why were those houses not locked? It could have been the other way around if they drank that paint, because some are very young, like 3 years, 4 years old. If they have maybe drank, or maybe there was a bottle of thinners there. So is it not part of the developer to secure part of the complex that is still under construction?
Well, as long as there are not any, massive, dangerous tools lying around and pieces of
Or holes in the floor,
holes
or
in the
something.
floor, something like that is a very clear obstacle or danger. I can't, unfortunately, if you know you're living in a complex where construction is going on, similar to our earlier question, I think with the emails that we had, we have to, as a community, also take active steps to warn our children not to go swimming in the holes. Similarly, to warn our children to stay away from these construction sites. So as long as those guys have maintained a reasonable status of safety, generally speaking, they don't lock up. I mean, in construction sites, sometimes there isn't a door to lock because the doors haven't yet been hung or fitted. Sometimes there aren't any windows on, so anyone can really climb in if they want to. A common problem, just as a matter of interest in construction sites, is often that homeless people actually occupy the half-built structures when it's cold at night and so on. So there are various people that get access to these sites, with even if there is a reasonable step being taken to secure the safety.
Okay.
All right, Tumi, good luck with that one. Thank you for getting through.
Thank you.
Thanks. Good night to you.
Thank you for taking my
Bye-bye.
call. Thanks.
Pleasure. Bye-bye. Okay, off to Three Rivers in the Vaal Triangle. Tabo, good evening.
Evening, how are you?
Very well, and you?
Can't complain much.
How can we help you?
Situation is more related to the upbringing of black kids. I'm sorry to use the term black kids. I'm in a dilemma with regards to my surname. I've tried a few avenues and it seems like I've exhausted all of them. So I just heard your show while I was driving now. The surname that I'm using now is from my mother's side, but the challenge is she was also using a surname from a step-parent. Now, on my father's side, they were never married. They had me while they were still young, out of wedlock, obviously. And my dad also is raised by a stepfather. Out of trying to find my real surname, I had this urge, and ultimately I got hold of the actual surname.
Mm-hmm.
The challenge now is I want to change to the real surname. My mom has passed on. My dad is using a different surname. I went to Home Affairs. I was told there's nothing I can do unless my dad changes his surname to the one that I say is the original surname. If he can't do that for me, then there's nothing that could be done. Now, I ask the question, if you go to Home Affairs, we've got all those age restrictions and all that. At the age of 18, you can be able to do X, Y, Z. Age 21, you can do X, Y, Z.
Yes.
Now, I wanted to know that now that I'm a young adult myself, I'm actually 27. Can't I then have the right to say, no, this is the actual surname, and my point of reference is these people that I've discovered, and my dad is not interested because he was not raised by this family. The reason I want to do this is for my bloodline, you understand?
Sure.
I thought you could do that anyway, because I know a young man who had a surname that he really wasn't very happy with, and they got married, and he then took his mother's maiden surname as his now surname, and there was no problem with that.
Yeah, but you see, the issue here is that the living parent took the surname of a step-parent, so it's one line back.
Can't you just take any surname you want?
I would think
I
so.
thought
This
you
is
could.
news to me.
I'm also quite shocked because I thought you could say, well, I don't like my surname, so I'll become Joe Bloggs or something because I didn't like the other one. I thought you could just do
change. I've actually had a client who's changed her first names and her surname on a number of occasions, we dealt with a transfer for her, and it caused a massive issue for us in order to actually prove this person's identity. She had actually changed the first names 4 times and her surname 3 times in the last 5 years. So
I'm sure I thought you could do this.
I would really, Tabu, based on my general knowledge, I'm quite shocked that this is the feedback you've received from
That doesn't sound
Home
right.
Affairs.
It's even strange that I even went to one of the attorneys. You subscribe to these legal firms and all that.
Yes.
And I went there for legal advice, and I was told that no, there's nothing they can do unless my dad, as Home Affairs says, they say Home Affairs is controlled by legislation. If it was something else, they would be able to say to Home Affairs, listen, this person wants to do X, Y, Z. Here's
Tabo, what I'm going to do,
power of attorney.
I'm going to put you back to my producer. Give him your email address. I'm going to make some inquiries tomorrow, and I'm going to email you as soon as I can find out something for you.
Yeah, I think
That doesn't sound right to me. But I'm going to put you back to the producer. Give him your email address, and I'll be in touch with you.
great.
Thanks a lot. Eh?
Thanks, Tabo. Thanks. That doesn't sound right to me.
No, definitely not. But I think let's work
Look into
together
it.
and look into it, because based only on my general knowledge.
And well, my experience with this other person, they just did it and it was no problem. So,
this is not a field that I specialize in.
No, that's why we need to look into it.
So let's look into it, but
it doesn't sound
hopefully we
right.
can.
Right, our last call for the evening in Durban. Nandi, good evening.
Good evening.
Hello, how can we help you, Nandi?
I thought to find out I had a bond in 1997. I took a bond, and I paid my bond and came. And I came to last year. They told me that my bond is 15,000, and they're giving me a 5,000 rebate. If I can pay that 10,000, they're giving me 5,000 rebate. I'll have to pay 10,000 if I pay it in last year August.
Yes.
So I said, no, I don't have the 10,000 to pay. I'll pay my normal installment. So in the end of last year, my husband lost his job and he wasn't working. So I phoned EPSA and I notified them that my husband wasn't working. So they told me, even if it's 50 Rand or 100 Rand a month, I must pay towards my bond, because I'm only paying towards the money now. The interest is finished. So I just want to find out whether that thing still stands or they can't touch my house or whatever. Because she said I can pay like 50 Rand or 100 Rand a month.
Do you have it in writing?
No, over the phone.
Unfortunately, well, at least they're supposed to record their phone calls. So, I see we're running out of time, but very quickly, if you owe on your bond and you're in arrears with the slightest amount, there's always a chance that they can actually attach the house and sell it. Generally speaking, if it's a relatively low amount, and with relatively low, I mean below 100,000 Rand, then they don't proceed, practically speaking, they don't proceed along those lines. But legally speaking, they can always, if there's an amount outstanding or in arrears, they can always use your house and put it on the market to get their money. So if they do that, you have constitutional grounds to start on. The Constitution is quite clear that you cannot make someone destitute in order to collect a debt. So there are certain requirements that you have to fulfill in order for a house to be put on the market. And if it's a small amount, the courts are not very likely to award
that.
It's
10,000 Rand.
No, then it's unlikely that they would, but I would maintain
yes, she said
at least
she wouldn't
a little
do
bit.
anything, but just to say, like, if I pay a 50 and 100, I'm paying something towards the house.
Exactly. So I think take the advice, but do remember that as soon as you can, you need to bring your arrears up to date.
Nandi, what I would suggest you do is make a note somewhere, which you don't lose it, of the date and approximate time that you had that phone call, because then at least if anything does happen, they can go back in their phone logs, and because they always record those calls, and then you can say, well, I spoke to somebody, and if you have a name, make a note of the name on such and such a date at such and such a time, and then they can go back and find that conversation so that you've got the proof there.
And I don't think the insurance even scans, because I took an insurance trying if my husband died, the house is paid, or if I
The
died,
insurance will stay until the bond is paid. Nandi, the insurance will stay until the bond is fully paid up.
Yeah.
Oh, okay.
That because the banks are very insistent that you do not ever have a bond of any amount without insurance on it. So because they definitely want their money somehow or some way. So
because
I can almost
a letter, something about life, a life account or something. They said, and I didn't understand.
Yeah, it's a life cover on the bond, basically, on the bond owner.
Okay, thank you so much for your time.
Good luck, Nandi.
It's a pleasure.
Okay, and good luck to your husband as well. Bye-bye now.
Bye.
Yeah, and we've been through the whole bond story, know exactly what all those things are. Now we don't have that bond anymore. We've moved the life cover somewhere else. No, don't even go there, because I literally have to take a tranquilizer when I think about all the paperwork. Paperwork is a nightmare when it comes to all of those things. But anyway, that's the end of yet another show. Thank you all of you who called in, and sorry to those Brian in Johannesburg, sorry we didn't get through to you, but if you'd like to pop through an email, that would be great. And if you have any questions you'd like to get through to us, I'll be giving you the email shortly. My thanks once again this evening to Nicoline Skuman-Low. She's a director at Skuman Law Inc., attorneys, conveyancers and notaries public and their practice here in Cape Town. She's been my guest on tonight's edition of The Law Report. Nicoline, once again, thank you very much indeed for joining us.
Thank you for having me, as always.
And back into the freezing cold we go.
Oh, yeah.
And Nicoline will be back with us again for another law clinic on Monday, the 10th of August. The Law Report is on the air, as you all know, on SAFM every Monday evening between 9 and 10. And a reminder, there's a list of available documents with lots of new ones. It's on Law on SAFM. That's the Facebook page. If you'd like any of those, post a message there. But please remember to include your email address, or you can email me directly on law@safm.co.za.